Welcome to Real Talk, Indiana's premier talk show on real estate investing, where we talk each week about investing your money right here in Central Indiana. The tips, tricks, do's, and don'ts, brought to you by CIREIA, Central Indiana's oldest and largest real estate investing association. Hello there, my name is Vicki Perry, and I'm the Executive Director of CIREIA. We have over 600 members, all active in or learning how to be active in real estate here in the Indiana market. This radio show is available on FM 95.9, AM 950, podcast on YouTube, and www.cireia.org. Join us each week as we talk about how you can make your money more active with better returns and help the community that you live in with real estate done the right way. Now, on with the show.
Hello, my name is Ron Watson. I'm the president of the CIREIA Board of Directors, and welcome to CIREIA's weekly show where we talk about investing in real estate the right way. If you've missed previous episodes, you can listen to them on the CIREIA channel on YouTube, or go to our website, www.cireia.org, and click on the calendar of events. Joining us again today is Brett Snodgrass, owner of Simple Wholesaling and one of the largest wholesaling teams in Indiana. Welcome, Brett.
Thanks, Ron. Excited to be here.
And also joining us again are Janet Hocker and Eric Downing from Hocker and Associates Law and Title. Welcome back, both of you.
Hello. Thank you. Glad to be here.
Thank you.
So Janet and Eric, we normally ask our guests how they got started in real estate. So why don't you just give our listeners a brief overview of how you got started in real estate law and the title business?
I've been a real estate attorney in the state of Indiana for 25 years. Almost right out of law school, I became interested in title insurance, which goes hand in hand with the area of real estate law, and opened my first title agency at that time. I've been an investor myself, and it's just kind of naturally flowed through the years that that's been my primary focus of my practice and business.
And I grew up around real estate. My family were investors, and so after college, I've kind of dabbled in several different segments of the industry, both from the builder side, contractor remodeling, as well as the new home construction. And then with Janet, I came on as the operations manager of the law firm and title company.
Awesome. Well, in today's episode, we are going to break it down. So thank you guys for breaking it down. This is for anybody out there that really wants to know the nuts and bolts of a transaction. So we're going to talk about documents, title insurance, purchase agreements, and we're going to go through a lot of different terms that you guys can define that someone is interested. We get questions all the time. What is a purchase agreement? What is an amendment? Things like that. So we're going to kind of go through these, and in this first segment, we're going to start from the beginning, and we're going to talk about, so someone wants to sell their house, for example. Let's talk about a listing. What is, they want to list their house. What does that mean, and define that for us? Sure.
A listing is simply an advertisement for the sale of a piece of real property. It can be with a house located on it, or it could be vacant land. And the majority of the time, the listing also includes what the seller wants to sell the property for, which is called the list price.
Awesome. So kind of dig into that a little bit deeper. Is there a contract that has to be signed with the listing? And if you list it, do you have to list it with a broker? Can you list it with your Aunt Margaret, or?
Well, today I would say there are more options than ever to advertise and list your house. I believe that the term probably originated in the real estate brokerage world, whereby a realtor would enter into a contract called a listing contract with a seller. And that contract would set forth what that realtor broker was going to do by way of marketing and advertising in other ways the home. Today, the term listing has almost become a generic term for any type of advertising for the sale of real property. We know there's Zillow, there's all kinds of other websites that you can do. There's for sale by owner. You can literally put a sign up in your yard. all of those ways. You can advertise in a newspaper, magazine, many different ways now are as to how you list a house.
Okay, so now you listed the house, and most immediately somebody wants to buy it, right? Generally, that's how that works. So we go right to a purchase agreement, typically. Can you talk a little bit about that? And by the way, there's a lot of things we're going to define here today, which I think are really, really good. So it'd be good if you want to remember a lot of this information, go to our website. All these definitions are there. And this also might be a good podcast you want to go back and listen to again and again. But talk through the purchase agreement for us.
So the purchase agreement is also considered or called a contract. Sometimes it's called the purchase contract, purchase agreement, offer contract. There's many different names, but any real estate transaction starts with a written document between the buyer and the seller, typically drafted or presented by a buyer who makes an offer. And that's the beginning steps of a real estate transaction where the buyer will put into writing what they're willing to pay, what other terms there are to the transaction, when they're willing to close, where they're going to, what they're going to do with the property, what they'd like to have done by way of inspections. It encompasses it can encompass a full litany of terms. It can also be as simple as, hey, I want to buy your property for this amount of money. I want to do it by this date, and it's signed. It could be as simple as that, or it could be a very voluminous document that kind of anticipates everything under the sun. So it starts with the offer.
So it depends on whether we're using Brett's ANT or not, but you can create your own document potentially. So if you go through this process, I mean, I know when I'm dealing with Brett, he likes to negotiate heavily. So we're talking about offer, counter, offer, rejection, accept. Can you talk about that process a little bit?
Sure. We've literally had people walk in our office with napkins.
Nice.
That's Ron.
I do have
right
napkins,
there. He grabs
yes.
a napkin from his restaurant.
Bar napkins at my bar. That's right.
Bar nap.
Because quite frankly, you just need to have it in a written format. And because those napkins aren't scannable and they can't be, maintained very easily.
And they can't get wet.
They can't get wet.
So that would smudge it.
We do have all kinds of documents with coffee stains on them, though, and sometimes those follow the whole transaction. But bottom line is you have it in writing, and then once the buyer has made the offer, then the burden shifts to the seller to either say, no, I don't like that. But I want to keep this conversation going. I'm going to make a counteroffer. And the counteroffer could be for one item or a multitude of items. So you say you want to sell it to me for $50,000. I want $55,000. Let's do that. Or you want to sell it to me with all these other terms and conditions. I'm going to counter many of those. After that, then it shifts back over to the buyer, and they can counter again. Literally, you can go back and forth with so many counters. I think what probably the layperson doesn't understand is that when you are back and forth with different counters, you need to remember that whatever you don't counter survives the transaction. So if you counter the price only, and then they come back with another price, you can't then go back and change another material term because it's already been deemed accepted. So you keep going back and forth to the point that you finally get an accepted offer. That basically means that all the parties have agreed these are the terms, it's signed, at that point it's dated, and you have an offer at that point in time that is a binding contract.
So just a question. I know that real estate investors, I think, are more used to kind of going back and forth and doing a lot of negotiating. But if you haven't been involved in a lot of deals, I think there's often reticence on the part of a buyer to say, I don't know, I feel like maybe we shouldn't keep doing this. But your experience, you see a lot of this back and forth in these kind of deals and transactions.
I see a lot of it back and forth with, individuals that are not using brokers and realtors. I believe that probably there's a lot of back and forth verbally before they finally get down and put it into a written format. And that's really okay. It's just that you need to know, and the reason realtors really don't do that very often is because unless it's in the written document that you've all signed and dated as the actual contract, none of those oral agreements would be enforceable, and they don't survive unless they're in the written contract.
Yeah, when we negotiate, we do a lot of verbal, just because of time.
Sure.
Because it takes a lot of time to write the counteroffers and all that. So I do the verbal, and then if they say, yeah, that sounds good, send it to me in writing, then I write it up. So we do a lot of that back and forth. You talk about a lot of it in writing, and the question I get asked a lot is actually last night at our meetup here in Fishers, somebody was asking, well, I know everything what to do, but I don't know where do I get these purchase agreements? Because you talked about a napkin, and I know you can buy purchase agreements, but do you have any? I know purchase agreements are all different, so where's the best place for someone to go to get some of these, counteroffer documents or a purchase agreement? Do you have any suggestions on that?
Well, you realize you're asking a real estate attorney that question. So we do not want you to go to a Staples or an online, vendor to obtain those, but you can. The reason we don't want you to, we want you to use a real estate attorney, is because we want you to understand that what is in that written document you're going to be bound to. But in reality, there's contracts all over the web. Like I said, they're at the office stores. And if you are savvy enough and sophisticated enough to understand what those document terms state, you can use those forms. You may form a relationship with a real estate attorney that would allow you to just continue to use documents that they're familiar with guidance throughout the time of your investing.
Okay, so I think that's a great point. So we only have a couple minutes in this segment, but you mentioned that there's lots of places you can find the documents. What are some things that you see in some of those documents that maybe that come up as potential problems for people that often create issues that you have to fix later?
Well, as you know, realtors have a specific boilerplate form that they have developed over years and years and years based on experience. It's not that they're perfect, but they surely anticipate a lot more potential problems than what maybe your just very simple contract would anticipate. I would say the biggest thing that we receive issues on with people just using like a office store is not giving yourself the ability to have an out based either on the condition of the property, the condition of the title, maybe the value of the property. Those three areas are probably the biggest because you can put contingencies into a contract.
Okay, so we're going to take a quick break here, but because I was going to use that very word. When we do a lot of deals, I always like to have contingencies. I always like to have, okay, this is what I want, but if something goes wrong, I don't want to end up with that property or in this situation. So we're going to talk about that. We have a lot more questions after a few messages.
Real Talk, brought to you by CIREIA, Central Indiana's premier real estate investors association, helping investors for 30 years. Whether you're a newbie or a seasoned professional, CIREIA has a wealth of information for you through meetings, classes, and networking. Check them out today at www.cirea.org.
And welcome back to Real Talk. I am Ron Watson, president of the board of directors, and today we're speaking with Janet Hocker, attorney and owner of Hocker & Associates Law, and Eric Downing, operations manager with Hocker Title. Also joining us is Brett Snodgrass. And I wanted to just circle back real quickly regarding some of those boilerplate documents we talked about. I know sometimes there can be state-specific issues that come up that are not really addressed in those. Can you just talk about that for a second?
Sure. So in the state of Indiana, we have a couple of forms. One is the lead-based paint disclosure, and that's actually a federal requirement, but Indiana has endorsed that. And that's for any property that's over the age, was built prior to 1978. It's a very straightforward document, and you're just basically to put a buyer on notice if you are aware that there is any lead-based paint. And since we're talking primarily about investing, that's usually not something that an investor is going to know, and you just need to state that. I've actually had sellers that always write that in the conditions of their purchase agreement, and they say very plain language, there could be lead-based paint, don't eat paint chips. And I think that's great because who doesn't understand that? And
Did they write that specifically for Brett?
Yeah. That's what happened to me. No, no, that definitely. And then there's another form too that just kind of go over that real quick. The seller's disclosure form, and is that a state-specific form that
That
we'd
is.
have? And
That's-
what does that mean?
So that's a form in the state of Indiana. You can actually Google it, Indiana Sales Disclosure Form, and it's a PDF document that you can either do online or you can actually print it off. But it sets forth a bunch of different questions regarding the condition of the property. And you can answer yes, no, or I don't know. And it's looking for if there are any known defects in the property.
Now, just real quick with that, if you know that the AC unit, the air conditioning unit doesn't really work, but you said it works great, and then they buy the property, can they come back and said, and have a lawsuit against you because you said that it worked? Is that a legally binding?
The seller's disclosure form has actually been around long enough that there's been quite a bit of litigation surrounding it. At the very beginning, the courts were very clear, look, this is not a warranty. It doesn't take place of you doing your own due diligence and inspecting the property. However, unfortunately for maybe some sellers, the courts have actually made that more like a warranty and have given more strength to that as far as a tool that buyers can rely on. The law does say, though, that if you take that property and you know of a defect, say in the air conditioning, and you hire a contractor and you have it fixed and you pay the bill, you can truthfully say it is not defective because I paid for the repair to be done. You don't have to say it was defective and now I've paid for it and it's not. You can truthfully say it's not defective. Just make sure you have the backup on that.
Gotcha. Interesting. I was always wondering about that. So those are documents. You got the lead-based paint disclosure, the seller's disclosure. You're going back and forth with the seller. You get an accepted offer. So what are the things that makes an accepted offer?
Well, simply, again, it can be just one offer and then it's accepted. There's no counters or anything. But it's just the document that sets forth the terms of the transaction that is agreed to by the buyer and the seller. It can consist of counters or not. And then the other items that can go into a full binding contract would be an amendment or an addendum. And they sound similar, and I will say they're not always used correctly. But if there's a meeting of the minds, then it's going to be enforceable. But an amendment is truly making a change to a prior term. And you see that come up a lot of times when the contract itself had a contingency for inspections. The inspections are done and the buyer comes back and says, you know what, I said I would pay this, but it's got a really faulty HVAC. I'm going to pay less than that. Let's amend the purchase agreement by changing the price. That's an amendment. That's a change to an existing term. An addendum is an addition. That's an actual addition to something on the contract that wasn't previously determined. An example of that would be, well, I went out and looked at the property and it looks like there's actually an outbuilding on the property. We didn't really discuss that. I thought it was on the neighbor's property, but I want to make sure that that's included. We're going to do an addendum and add that to this contract. That's the difference between those two.
I just got a quick question there, Brett. Sorry. I mentioned contingencies before. I like to use contingencies in our deals. What are some of the common things that people use as a contingency in a process?
Well, far and away, the biggest one is inspection of the property. And for investors, almost all investors have, an analysis that they go through that they want to make sure that what they are purchasing is going to work within their financial analysis, their speculation, all that, how much money they're going to have to put in it. So inspections and the condition of the property is actually probably one of the biggest ones. Another big one is maybe appraisal. They want to make sure that by whatever source they use, that the property is going to appraise for a certain value. And if it's under that, environmental issues is another one. Gosh, nobody wants to buy an environmental issue, and you find that out and you basically just want to run away. Not always, but those are some of the some of the biggest things that I see.
Okay.
We love mold. That's if
You,
property has
you're
mold,
looking for mold in properties. Okay.
That's one of my contingencies. It has to have mold. No, I'm just kidding. So one of the big questions that I always get is about earnest money. And so you get a signed purchase agreement, accepted offer, and there's always something in there about earnest money. So describe what is earnest money, number one, and does every accepted purchase agreement have to have earnest money?
It does not.
Okay.
Not to be binding. I think that is probably a misconception out there. But if you think about it, when you have, really the law only requires that a contract be in writing, signed and dated by the parties that are agreeing to. You can recite in that contract that you're going to pay $500 down as earnest money. And it used to be that really was the binding consideration for that contract. But the law has evolved, and basically you could withhold earnest money to try to get out of the contract if that was truly how the law enforced that. So earnest money is truly a down payment, and it's basically to kind of make the buyers have some skin in the game. Are you serious about doing this or not? If people don't want to pay earnest money, that might be a red flag to you, but it's not going to change the binding nature of a contract that has been signed by a buyer.
No, that's interesting because I always I had the idea in my head that it was basically required. I mean, you talk to a realtor and that's kind of how they think, right? Is that, yep, got to have earnest money. It's on that agreement there. But you could potentially do a deal without it, I guess.
Right. You can put that in there, but if they don't actually deposit the earnest money, you could still enforce the contract.
Okay, so a little bit more about money then. We have the earnest money. Escrow is something that is a term that comes up, good funds and those kinds. Can you talk about those items?
With regard to escrow, that is a term that is used to describe the procedure whereby you have a contract and we're all moving in the direction of closing. But what happens in that in-between time? Who's going to hold the earnest money? Who's going to coordinate all of this transaction so that we can all make sure the right parties are at the right place to sign the final closing documents? And so typically escrow is that in-between period of time where everybody's doing their due diligence, money's getting freed up, money's getting deposited. There's some states, for California, for example, they are truly an escrow state. And what that means is that they close and then they have a 30-day waiting period, primarily, sometimes longer, whereby the money sits in escrow, sits there, and nobody can take possession of the property. And they can kind of wrap up loose ends over a period of 30 days before it's finally closed and the parties are good to go. We are not an escrow state in Indiana. When we say you're closed, and the parties are moving on in their separate directions. But we do escrow for funds and documents and things like that prior to the closing.
And then as far as good funds go, that's actually a law that was written in 2009. Indiana State Legislature said that in order for a closing to occur, it has to be table funded. And they set amounts, limits on how that money can be brought to the table. So for example, if it's under 500, it can be a personal check. If it's between 500 and 10,000, it has to be certified funds, either through a cashier's check or a wire. And if it's over 10,000, it has to be in the form of a wire.
So table funded means what? Just
that at the time of closing, it's funded.
I see. Okay.
And that's really evolved because I remember when I first got into investing, and we could at least use cashier's checks for 50 grand or whatever it was, right?
Yep.
And a lot of sellers don't understand that. I actually had a guy the other day want a duffel bag full of cash. Do you guys do that? if that's what they want?
You really can accept cash, but we're not. We don't have guards that could help us get that to the bank.
Okay.
I mean, honestly,
because he didn't trust anything else. Mm-hmm. His idea of good funds was just cash, I guess, in a bag.
We've had literally where we've had an employee walk with the person that had the duffel bag of cash to the bank. They carried it and we deposited it in our bank account at that time. I mean, cash is still king, but it's just not the preferred mode of funds when you're dealing with insurance and the Department of Insurance, the state of Indiana. It's just a much better tool to use
And logistically, it's more
wires.
difficult to create,
It is.
put
Well,
together
we're not a
suitcase
bank.
of cash.
I
And
had a guy.
to count that out.
You're
I had a
right.
guy bring in, I think, 35,000
Wow.
like one time, and I felt like I was doing something wrong.
Right.
I don't know about all this.
It doesn't smell right when that happens.
Kind of makes you feel a little dirty, maybe. I don't know.
Yeah, I was scared. Anyways, so I want to dive into the title process a little bit. You talked about good funds and earnest money. Just kind of hit. What's the first step? The purchase agreement goes to the title company, and then what do you guys kind of do from there as far as the first steps?
So once we get the purchase agreement from whatever party provides it to us, oftentimes a real estate realtor or investor, we then move right into ordering a search on the property. That search contains all of the details going back oftentimes 30 years. On a commercial property, it'll go back 50 years. And those limits are set by our underwriter, so they're specific to different title companies. But the search then returns all of the history of ownership, liens, judgments, encumbrances, everything that would basically convey or prevent conveying marketable title. And once we get the search back, we then type up what's called a title commitment, which then contains all that information that I just said we get back in the search, and we send that to all the parties involved. So the title commitment is going to be kind of the instrument that all the parties can then say, okay, here's what the title company has found on the property.
So that's Eric Downing, and we're going to continue working our way through the sale of a real estate transaction as we take a break here. I did want to mention that a lot of this information is on our website, and there's definitions of a lot of these terms there too, and you'll be able to listen to this broadcast as a podcast on our website as well. So we're going to take a quick break and hear a few messages from our sponsors.
Real Talk, real estate investing the right way. Brought to you by Central Indiana's premier real estate investors association, CIREIA. Check out upcoming guests weekly on the calendar of events at www.cirea.org.
And welcome back, and thanks for listening to Real Talk. I am Ron Watson, president of the board of directors of CIREIA, and today we're speaking with Janet Hocker, attorney and owner of Hocker and Associates Law, and Eric Downing, operations manager with Hocker Title. Also joining us is the famous Brett Snodgrass.
Thanks, Ron.
Yes, sir. So we've been working our way through the real estate process, transaction, and I'm going to throw you a softball here, but do the contracts for real estate transactions have to be in writing, and if so, why?
Well, in the state of Indiana, and actually most states, there is a statute. It's called the Statute of Frauds, and it states that there are certain contracts that must be in writing. Anything pertaining to real estate does, except for a lease that's less than 3 years old. Less than 3 years in term, but anything relating to real estate has to be in writing pursuant to Indiana statute, and it's truly just to prevent fraud and injury to individuals that are contracting for land. The contract has to be in writing. It has to be signed by the grantor, the person that's selling the property that owns it, and by the buyer, and the conveyance after that then has to be in writing as well.
Awesome. That answered your question, Ron.
Thank you. That was a good answer.
I want to go back and talk about the title company in the first place. So we talked about getting a purchase agreement accepted and then going to the title company. But in our experience, we've had a lot of buyers and sellers. They don't want to use a title company. They want to come and meet at a McDonald's and sign the paperwork there, and we give them the duffel bag full of cash like we talked about and then go on our way. So why is it important for someone to use a title company, and what's the purpose of all that?
So the purpose of a title company is to have an independent third party analyze that the property is owned by the person that states that they own it and entering into the transaction, and the condition of the property pertaining to the title. Someone that is skilled in searching the public records and looking to see, are there any liens on this that as a buyer I'm going to assume? Are the taxes paid current? Does this person even own the property? And for investors, I always say, if you don't want to do the full service title services, you guys can do your own closing. That's fine. We'll talk about what it means to have an insured closing maybe here in a little bit. But if you want to at least have a title company looking out for your best interest, do the minimum, have them do a title search and give you a report, pay for that part of it, just so you know as a buyer what it is exactly that you're purchasing. I recommend doing the whole transaction with the title company because for a relatively, small one-time fee, you're going to get a lot of services that are going to be the best way to manage the risk that you have.
And I want to speak on that a little bit because, again, we've had experiences. You talked about if they even own the property. There's a lot of instances where someone might be on the title, but then there's an ex somewhere that they don't give their permission to sell the property, and we ran into a lot of challenges, and they're on the title as well. So yeah, that's important. Let's talk about title insurance, though. So you do the title search, and you find out if there's no liens and any of that. But do you give that buyer or seller protection to make sure that there are no liens and all that?
We do. Eric had spoken about issuing a title commitment or sending out a title commitment. In layman's terms, that's just a report from the title company saying, here's what we found, and we will actually ensure, as long as these things are taken care of, or maybe there aren't things to be taken care of, but that the documents are signed correctly, we'll actually ensure that this title is good and will defend you as to any claims, if there is any valid claim of record that later turns out that we missed. And you really need to read that title commitment because it does put forth what the exceptions to that would be. And that actually goes back to you as far as doing some due diligence as well. The title companies do not go out and physically inspect the property or even determine if anybody is living there or even if the building is there. Unfortunately, we've actually had situations where the building was not even there and there had been a fire and the investor had not actually been to the property prior to closing. So,
wow.
So Brett learned his lesson. I think, but
dang it.
Don't take
That was a bad day.
Don't take the bag of cash to McDonald's until you've checked out to make sure that building is in existence. Oh, boy.
Correct. And the problem is that it's not hazard insurance. It's truly a title insurance policy that's only going to ensure that the title is clear as what's of public record. But make sure you still do your due diligence with regard to the property.
So I have a question about a topic that I hear people mention, recording documents. What does that actually mean, and how does that work?
Well, again, that is a statutory requirement that for an interest in real estate to be valid against another party, it must be recorded. And the reason is that if people are having informal sales among themselves and they're doing deeds back and forth, you as an interested party for that real estate could come forward and say, well, I'd like to buy that too. Well, how are you going to know because you had not been a party to all those other deeds unless you can go to a resource that's going to tell you and give you what they call constructive notice who owns the property. In Indiana, there's different states treat it differently, but Indiana says that priority of interest in lands are based on the date that document is recorded. So say that Dad gives son A a deed to the property on May 1st. Then Dad gives a deed, and that deed does not get recorded. Dad gives an interest to son B on May 2nd. Same property. I don't know why Dad did that, but he did, and believe me, it does happen. And son B goes down and records his deed. At that point, who owns the property? Well,
I don't know. Who owns it, Janet?
Son B, the person.
I was going with son B myself.
That recorded the deed. At least as to any other claims that could be made. So you record it to put the world on notice that I own it.
Interesting.
So notarization, what does that mean? I've had documents notarized. Does somebody just have to say, yep, that's really who I am? Is that what that means?
That's what it means. It means to be acknowledged. That the person that's signing it has presented some sort of identification or is personally known to a notary who is bonded and is taking an oath that says, I'm not going to notarize something unless I go through these steps and verify that person. Also to help prevent fraud.
So notary, what are a couple of the documents that need to be notarized, and I guess why do they have them be notarized?
Some have to be notarized by statute, and the main one would be any conveyance in real estate. So the way you convey property is by deed and sometimes by affidavit. So those have to be notarized because that's the only way that you can have the parties acknowledged under the law. In Indiana, you also any document that you're going to record must be notarized. That's a recording requirement. So mechanics liens and other things like that have to be recorded or have to be notarized. There's lots of documents, though, that are binding documents that do not have to be notarized, but are still nevertheless a binding contract.
Interesting. So we're talking about some awesome title stuff, why you should use a title company, title insurance to be protected, recording documents. Hope you guys are really, really listening to that. Documents need to be notarized. So let's talk about breach of contract. And is that an attorney term? I don't know, breach. We use cancel.
It makes me cringe when I hear the word, but
I know.
That doesn't sound positive.
Well, breach literally means break.
Okay, gotcha. So breach of contract, how does that happen? What are some reasons that might happen? And then what can somebody do about it, if someone changes their mind or breaks a contract?
In my experience, the two reasons that people breach contracts is one, buyer's or seller's remorse. They've gotten into it and they change their mind. Mm-hmm. Just a straight up remorse. There could also be other reasons that kind of is a remorse. Had a husband and wife here just recently that they went through all of this, and then the wife had said that I don't want to do it, I don't want to do it, I don't want to do it, and she didn't want to do it, and the husband finally caved and said, "Okay, we'll back out of the contract." And
good man right there.
Yeah,
good man.
He was thinking ahead. So what happens to that? I mean, can they get out of the deal? I mean, what are the recourses there?
There's ways it's a contract. So there are a couple of different ways that courts enforce that. Specific performance is always brought to me. Can I just make them do this? Can I make them sell me? I really want this house. Can I make them? It's really not usually a remedy that courts will enforce. They just don't like to force people to sell property or buy property that they don't want. So normally what happens in that scenario, if it's a breach that is supported by the evidence and the law, the court will basically give the seller, what are your damages? Well, I sold it to him for $100. He backed out. I ended up selling it for $95 and had to pay an extra, A, B, and C. Then the court will grant damages to that seller for what his actual losses were.
What about the earnest money we talked about? Can they lose that potentially?
They can lose the earnest money, or they can gain the earnest money from the seller standpoint if there's cause for that. And you can also do a breach agreement by agreement. We negotiated one, the one I was telling you about. The husband and wife disagreed. That poor seller ended up paying like $5,000, I think, to get to the buyer just to get out of that contract. And it was all by agreement. I was happy there was no courts involved. So you can do that as well. Communication is key.
Awesome.
So do you see that very often? I mean, do people get to the last hour there and then change their mind? Or is that just kind of a rare occurrence?
It's really pretty rare. I think if people make a contact to an attorney like, hey, what are my legal risk if I decide to break this contract or get out of it? Or they'll present like, I don't want to go through with this for this reason. And an attorney, or at least sometimes even a realtor, can say, yeah, you're probably going to be liable. Most of the time they'll weigh that in and just determine it's not worth the hassle of even going through a potential lawsuit. The other, I said there's usually two reasons. One's buyer-seller remorse, and the other one is just got a better offer. Mm-hmm. So again, that's still a breach if you had already agreed to sell it at a certain price and didn't leave it open to accepting other offers.
That would be a painful thing if you thought you had the deal and then somebody got a better offer.
That's what makes the world go round.
And that's why there's lawyers too. That definitely helps. So we have about 1 minute left. I just want a quick question. As an alternative, can somebody assign that agreement or that deal to somebody else? And if they don't want to go through with it, is that a possibility?
As long as the parties agree, either in the original document itself that it's assignable, or through one of those items like an addendum that says, hey, I'm going to assign it. If you don't care, everything's going to stay the same, but someone else is going to honor it.
Okay. So there are some options if you run into a last-minute problem or change of heart or change of bank
Right.
bankroll or whatever it might be, that you're not necessarily doomed to buy that house necessarily, depending on the situation. But we're going to take a quick break. We do have a lot more to get to. We have the hot seat segment coming up.
We got some amazing hot seat
Amazing
questions.
hot seat.
Yeah.
This has never before happened, so
That's
this is
right.
going to be really, really good stuff. So we're going to take a quick break. Here are a few messages from our sponsors, and we will be right back.
Central Indiana's premier real estate investors association, helping investors for 30 years. Whether you're a newbie or a seasoned professional, CIREIA has a wealth of information for you through meetings, classes, and networking. Check them out today at www.cirea.org.
And welcome back to Real Talk. This is our final segment of the show this afternoon. I am Ron Watson, president of the board of directors. And today we're speaking with Janet Hocker, attorney and owner of Hocker and Associates Law, and Eric Downing, operations manager with Hocker Title. We're going to now hit the hot seat segment of this program, and I wanted to start off with a question from Brett. He's really excited about this part.
I am excited. I always love this hot seat section, and we're going to start off with talking about something that I do all the time, and we are a wholesaling company, and I know that's kind of a buzzword in the real estate investing community right now, but Ron asked about getting out of a contract and not breaking it and maybe being able to assign the contract, but people actually do that as a business. So, and it's called wholesaling contracts or flipping contracts, whatever you want to call it. So talk to us about that. What does it mean when someone, again, gets a contract and then assigns the contract, and why would they do that, I guess?
So wholesaling is a very viable tool for investors. I think a lot of times people hear it in the context of it's a way that you can get into real estate investing without spending your own money. The reason being is that you are not purchasing the real estate itself. You are entering a contract, and then you are selling that contract to another party, and you receive a fee, normally called an assignment fee, for that, so that the buyer of the property is paying the seller, and then you receive an assignment fee just because you sold that contract.
Yeah, awesome. That's a great explanation. Yeah, basically selling the contract.
It sounds easy, Brett, but you would know that it requires
sounds really
work,
simple.
and you have to be hardworking and really involved in the real estate community for that to work on a regular basis. Brett does a great job.
This is not about Brett. It's all about Brett. I'm just kidding. So I just said I did have a question though about this. I hear this term that he uses and others, the double closing, simultaneous closing. What is that? Sometimes people ask this: is it even legal? Can you talk a little bit about that?
Sure. So sometimes you're in the investor world, and you all talk to each other, or you should be. It's probably good business to be able to know who other investors are. And you might know that someone is looking for, they'd mentioned to you, a 3-bedroom, 2-bath in the Fountain Square area. You kind of kept that in the back of your mind because you stumbled across a 3-bedroom, 2-bath in the Fountain Square area. And you approached the seller to purchase that property. And you know that you could probably sell it really quickly. Maybe you make repairs, maybe you don't. Maybe you're ready to just sell it at the same time that you buy it, or close to. So you will reach out to a title company and say, hey, can I do these at the same time? I'm buying it, but I want to sell it the same day because I already have a buyer for it. So that's when you conduct what's called a double closing or simultaneous closing. The key to that is that the closings have to be fully funded, independent of each other, so that everybody can leave that transaction paid in full. And I think maybe one of the biggest concerns that people have is, well, I don't want to tell the seller that I've already sold it to a buyer. And there are scenarios, we're not allowed as a title company to just release that information, But I will tell you that it gets kind of dicey when if the transaction doesn't fully go through, we're not able to fund it for any party, and therefore
You have a lot of mad people.
your seller might find out because they're not there to pay for that. So have to be fully funded for everybody to walk away that day from the closing tables.
Interesting. So yeah, we do double closings, and I want to talk about some other aspects of. A lot of people don't really know much about lending or even private lending. I've talked to a lot of my friends and family, and we start talking about private lending, and they're like, "I don't even know what you're talking about. That doesn't have to go through a bank, a traditional, Chase Bank or Huntington or whatever." So let's dive into that a little bit, and because a lot of people have asked me to lend on a property so they can borrow from me. So what are the documents that need to take place for a person to borrow money on a house, piece of real estate?
Sure. So you're basically talking about either a seller financed or a private finance transaction. And really, you're just stepping into the shoes and doing the same types of things and documents that a mortgage company or a bank would do. You want to make sure that you have protection, that if the buyer defaults on the loan that you made to them or that the private investor made to them, they have a remedy. And usually the remedy is foreclosure. So the borrower signs 2 documents, and one is a note. That's a promissory note, promise to repay the amount of money at whatever interest rate you decide on. The second document that goes along with that is the mortgage. I like to say that all lenders, private or public, don't want to rely just on your promise. They want more than that, and they want a mortgage which is recorded and creates a lien on the property that says, if you do default, I can go through the process of foreclosure and take that property back and sell it to satisfy the loan if you're unable to do so. So those are the 2 main documents that you have in place. There's some other seller financing tools, land contracts.
I was going to ask you about that specifically, because that was a question that I often get to. Can you talk about a land contract, what that is, and how people can use that?
Sure, a land contract, sometimes people call that contract for deed, installment contract. They're all the same thing. It pertains to a transaction where, as the seller, you are selling the property to a buyer and allowing them, usually with a down payment, preferably with a down payment, to pay for the purchase price over a period of time in installments. And the difference between that and a note and a mortgage is that in the note and mortgage scenario, the seller actually deeds the property to them at the time they take out the note and the mortgage. In a land contract, the land contract is executed, but the deed is not given until the contract is paid in full. So it's a little bit of a different animal in that you have some different remedies if there is default. You may not have to go through a foreclosure. You could just cancel the contract.
So why would a seller want to get engaged with a land contract? What's an advantage for them?
So the advantage is basically the remedies available by when they default or if they would default. Nobody likes to talk about default, but that's what we deal with on a regular basis. But when a mortgage is in place and there's a default, the law requires that the seller go through foreclosure. Foreclosure means you don't just get the property back. You have to go to court, and you have to actually have it set for a sheriff to sell it. And then whatever the sales price brings, you get to apply to what you owe. On a land contract, you can actually go to court if a lot of money hasn't been paid down and actually cancel it and get the property back. It's quicker. You don't have to go through the sale, the sheriff's sale, and it really gets you back to having that property in an income producing. So it's really an advantage for default.
Okay, but if I'm a buyer, what would be the advantage for me to be involved with a land contract? Is there an advantage for me to do that?
Well, usually it's that you're not able to obtain financing from either conventional or FHA means. Sometimes credit problems, sometimes down payment.
So it might be easier for me to get into a property if I don't have the credit rating that someone like Brett has and the bags of cash that he has.
Absolutely.
Okay.
It gives you a piece of buying the American dream.
Okay.
I have a quick question that might put you on the spot here, but This is another buzzword that I hear a lot about at CIREIA. I know people talk about is buying a property subject to. And can you kind of explain that a little bit? And is that legal to buy a property subject to the seller's mortgage?
Well, it's not illegal as far as the buyer is concerned, because you can buy properties subject to whatever you choose to. When it is the seller's mortgage that you're buying it subject to, you're basically making an agreement between the buyer and the seller that the buyer will agree to pay the seller's mortgage. That is not an assumption of the mortgage, because a true assumption has to be approved by the bank or the mortgage company. As a matter of fact, it's probably in violation of the terms of the mortgage. However, by and large, those transactions work smoothly as long as the mortgage company is getting paid. There are considerations. That is that because the bank is not a party to it, what happens if you need to communicate with the bank? The seller has disappeared or died, and you need to make sure that you can contact the bank and find out where to make payments if necessary, get a payoff. So there's a lot of documentation you want to make sure is in place, as well as making sure the seller is informed that, you're still obligated, because we are only making your payments. If something changes, you're still obligated.
So, Brett, I think we did a pretty good job with the hot seat segment again.
That was a lot of good questions.
It was tough.
And just real quick, I know that this is so much information if you're listening, and we just regurgitated so much at
we did,
you.
Sir.
But is there any resources that you can mention that if someone wants to learn more information about any of this, like contracts, owner financing, and notes, and just stuff like that? Like, do you recommend anything? Do you guys do anything at your office? Or I know CIREIA obviously has so many resources, but
well, Eric offers an abundance of services, really free of charge with regard to advice, and then we have lots of packages that we have put together. Eric, what are some things that you do for new investors, or even investors that are veterans that just want to kind of refresh their course?
So my background is in consulting and coaching, and so that's one of the tools I bring to the table with our customers, and helping them from all aspects of their business, but predominantly with what documents they need, advice with title and purchase agreements and closings. So we at our website at www.hockertitle.com, under the resource tab, kind of an easy learning opportunity for folks is we have over 100 videos. They're short 30 to 60 second videos that just explain a whole lot about start to finish with a real estate transaction.
So I just wanted to can you give contact information real quickly so people can reach out to you guys?
Yeah, so our phone number is 317-578-1630. The law firm website is www.hockerlawfirm.com, and the title is hockertitle.com.
Thank you very much. Brett, did you want to share contact information as well?
Sure, Ron. So you can go to our website at simplewholesaling.com that has all of our properties in Indianapolis, and also has resources just about wholesaling in general. We also teach a meetup that's linked, an affiliate of CIREIA. It's on the fourth Wednesday of each month, and that information is on our website too at simplewholesaling.com.
Thank you very much. And this week at CIREIA, we have our main monthly meeting, and this week it's going to be on Wednesday the 5th, not on Thursday. We're excited to have Chris McClatchy here, one of the top national speakers. Chris teaches his zero-down strategy using creative financing. You can get times and locations for all of our meetings at www.cireia.org and click on the calendar of events. Whether you're a beginner or experienced, we have members to help you and classes to meet your needs. Thanks for listening today. I wanted to thank Brett and thank Janet and Eric as well, and we hope that you'll join us again next week.